What is the controversy surrounding VA compensation and court awards for Camp Lejeune water contamination victims? To answer this, we delve into the complexities and controversies surrounding Veterans Affairs, VA disability compensation, in relation to the Camp Lejeune water contamination incident. Veterans exposed to the contaminated water at Camp Lejeune who develop specific health conditions as a result may find themselves eligible for VA disability compensation. However, the situation takes a complex turn when these veterans receive court-awarded compensations for their ailments. The VA has stated that any court-awarded compensation for conditions linked to the Camp Lejeune water contamination may be offset by the amount of VA disability benefits the veteran has already received. In simpler terms, if a veteran has been compensated by the VA for a disability related to the Camp Lejeune incident, and then receives an additional amount from a lawsuit settlement or court award, the VA may reduce their future benefits by the amount received from the court, effectively recouping the cost. This policy originates from the principle of preventing double compensation for the same disability or injury. While theoretically fair, it has sparked concern among affected veterans, especially those who have relied on VA benefits for an extended period. The impact varies, with veterans who recently began receiving compensation feeling less of a pinch compared to those who have been receiving benefits for a longer duration, such as 10 years. Adding to the confusion is the VA's ambiguous communication regarding this policy. The statement, "yes, potentially," in response to whether court-awarded relief will be impacted by previously received VA benefits, muddies the waters for veterans seeking clear answers. We also explore the prevalence of scams targeting veterans eligible for compensation under the Camp Lejeune Justice Act, CJJA. Veterans are urged to beware of fraudsters who may offer unnecessary assistance in filing claims, often demanding a fee. The VA stresses that veterans do not need to hire a lawyer or any outside help for filing claims related to presumptive conditions linked to Camp Lejeune, as long as they meet the established time criteria and have a current diagnosis for one of the specified health conditions. These specified conditions include adult leukemia, various forms of cancer such as bladder, kidney, and liver cancer, multiple myeloma, non-Hodgkin lymphoma, and Parkinson's disease. Veterans who served at Camp Lejeune or the adjacent Marine Corps Air Station New River in North Carolina for at least 30 days between August 1, 1953 and December 31, 1987, and have been diagnosed with any of these conditions, are encouraged to file a claim. The importance of meeting both the service criteria and having a diagnosis for one of the recognized conditions to streamline the claims process is underscored. The VA's role in acknowledging the service at Camp Lejeune is highlighted, with a strong emphasis on the necessity for veterans to submit evidence-based claims, particularly for presumptive conditions. A VA-provided map delineates the specific areas of Camp Lejeune covered under the benefit, making clear the zones where veterans must have spent time to be eligible for compensation. This exploration highlights the complexities and controversies surrounding VA compensation and court awards for Camp Lejeune water contamination victims. With better understanding comes better preparedness, and with that, a more hopeful future for those affected.